The impulse of the reasoning behind the ruling, and maybe from there we'll be able to decide as to the next course of action.
So you wouldn't say this is the end of the road?
Well, but let's just get the reasoning first. When we get the reasoning, of course, the 3-2 ruling suggests that the Supreme Court itself sees some reasoning in the arguments that we made in court. It tells you that our argument or the reasoning that we advanced in court was quite potent. And so let's get the reasoning, and when we're able to get the reasoning, we'll be able to decide what we intend to do after assessing the reasoning.
What do you make of the fact that...
Because Assafuah versus Attorney General clearly tells you that in reading the Constitution, you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case. In fact, even today, the Interpretation Act of Ghana tells you that you have to read the Constitution purposively. Purposively means that the letter and the context is very much important. It is on that basis that even the Injunction case, where a prima facie that will have to be established in the case of a Chief Justice, which has not been stated clearly in the Constitution. Injunction said that we have to establish a prima facie. So if anybody tells you that something will have to be stated in the Constitution before some potential will have to be given to it, I don't think that is the law. Let's wait for the reasoning and see what we can do.
Are you disappointed?
Charlie.
Your initial reaction to this particular ruling?
Well, I think that I find it quite intriguing to start with that the acting Chief Justice himself decided to pursue this, and as I indicated, I find it very incongruous because indeed, if at all there's any beneficiary from all of its involvement, and the acting Chief Justice is really a direct beneficiary of this. Of course, it's a constitutional injunction for him to act as the next Muslim, but clearly we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there has been a dispute as to the status of the Chief Justice in this country, start from 1980 before the Attorney General, start from 1983, 94, Aban, and we go to 2005, there about J2 and all. The Chief Justice in question paneled the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. We wait for the reasons. When the reasons come, we definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application, no doubt, had merit and we know what to do. All right?
You're being like the president's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146.
Had not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it adjudicated on the arbitration matter. Of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his appointment before triggering the process. And that is what is in dispute before the court. my contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process before Article 146 can be triggered. Thank you very much.